Court of Appeals for the state of Kansas is now in session. The Honorable Tara Warner now presiding.
Thank you. Please be seated. Good morning, everyone, and welcome to this morning's arguments before the Kansas Court of Appeals. My name is Sarah Warner, and I am the Chief Judge of our court. And I am joined today by a very distinguished panel. So to my right, your left, is Judge Tom Malone. Judge Malone is the most senior member of our court, and he was appointed to the court in 2003 after serving on the Sedgwick County District Court for a dozen years. And Judge Malone is also a former chief of our court. And then to my left, your right, is the junior judge on today's panel, Judge Stephen Hill, who was also appointed to the court in 2003. Judge Hill is the longest serving judge on the bench in Kansas, having served as a judge for, I think, more than 45 years.
Something like that.
And before he was on our court, he served as a judge down in Miami County. We're also pleased today to welcome several law students from Washburn University School of Law. And so welcome, everyone. After today's arguments, the judges will step out briefly and take off our robes, and we might come back in and talk to the students for just a minute if you guys have time. The court today, this morning, will hear 3 arguments. Between the second and third cases, we will take a brief recess for some change of personnel, as I will step out and Judge Gardner will join the other members of the panel. In preparation for today's arguments, we have thoroughly reviewed the briefs that have been submitted by the parties, along with a legal memorandum that has been prepared by a research attorney and the appellate record, so everything that has been submitted to the court. So we are very familiar with the facts of each case, and we encourage the attorneys to just jump right in to their legal arguments, because of course we only have 15 minutes per side. With that, I'll call the first case on this morning's docket. That's case number 126678 out of Shawnee County, State of Kansas, Appellee versus Courtney L. Kuipers, appellant. Would the parties please come forward and then state their appearances?
May it please the court, Your Honor, Grace Tran of the Appellate Defender Office on behalf of Courtney Kuipers, present and ready for argument. And may I reserve 3 minutes for rebuttal?
3 minutes are granted.
Thank you, Judge.
May it please the court, the state appears by Deputy District Attorney Jody Litvin.
Thank you very much. And with that, Ms. Tran, you may proceed.
Good morning, and may it please the court, Grace Tran of the Appellate Defender Office on behalf of Courtney Kuipers. In this case, the district court erred because the police illegitimately arrested Ms. Kuipers, which, and without that illegitimate arrest, the police could not have extended the traffic stop and ultimately discovered the drugs in her car. And so that evidence should have been suppressed. So first, turning to the issue of the illegitimate arrest. So Ms. Kuipers was purportedly arrested in this case for littering. And what happened was that after the initiation of the traffic stop, the Officer James.
Oh, just a second. It didn't start. Interaction with your client and the police didn't start with that stop, did it? According to what I see in the record, and maybe you can clarify something for me. The officer saw her at a stop sign hold a blowtorch outside her window and was hollering something. Now, it's not clear in the record. Perhaps you can tell me, was that blowtorch lit?
I believe that the officer thought that the blowtorch was unlit.
Was unlit. All right. Well, I think that's going to signal something to an officer, isn't it? What's going on here? She was the only person in this car, correct?
That's correct.
And then once the light changed, off they went 65 miles an hour down 29th Street. Is that correct?
Your Honor, I think it's actually the reverse. So the officer Jane saw Miss Kuiper speeding, and then she stopped at the stoplight. And so he was behind her, but I don't think he had his lights and sirens on yet. And then at that point, there was the yelling and the blowtorch. And then he turned on the lights and sirens. And so when the light turned green, she then pulled over into the Crunch Fitness parking lot.
Can you see why that would attract an officer's attention? And then 65 miles per hour in a 40-mile-per-hour zone?
Sure. And I think, so he pulled her over and because of that attracted
Well,
attention.
she didn't pull over, did she? She drove right into a parking lot and whirled around and parked in the middle of the parking lot, correct?
I think she quickly pulled off into the parking lot and stopped abruptly in the middle of the parking lot. But I think, given the fact that it was like 2 a.m, I think she was trying to quickly get off the road and pull over and stop once he had turned his lights and sirens on.
But then she got out of the car.
Yeah, so she did get out of the car and the officer told her to get back in. I think they went back and forth a couple of times through that. But ultimately, what the basis was for the arrest that the officer, testified about and had written down was the littering. And so it wasn't.
No, it was, I observed all of this behavior, and in my opinion as an officer, she was likely under the influence of drugs and she had littered.
Right. I mean, I think on the arrest report, it is the littering that's cited, and the officer testified that it was the littering that gave him the ability to arrest her. But I think.
Well, the officer doesn't get to decide what gives him the ability to arrest her. That's certainly one of the reasons that he provided. But the court decides whether the officer had the authority to arrest.
Sure. And I think sort of, I guess, regardless of if the officer's decision or the court, the facts of the case show that she didn't actually litter. And so there was no crime that he had observed arrestably that he could have arrested her for. And that was what the district court relied on when it said this car was just in a public place. So the drug dog sniff of the car wasn't a search. And so if you don't have that arrest, then you don't have that car being in a public place. The drug dog isn't able to search it. So then you have to get into, the traffic stop would have been ongoing, but for the arrest. And so then I think you need to get into what could that traffic stop have been extended at that point. And so.
This wasn't one of those situations where they had to call for the drug dog, correct?
Correct. Yeah. So he had it in his car.
His partner was the canine.
Yes, that's correct.
So, and what, it took about 3 minutes between her being handcuffed and then the drug dog alerts, something like that, 3-4 minutes?
That sounds right to me. But I think so.
That's not too long a detention, is it?
Sure, it's not a long time, but that the standard is a measurable extension of the stop. And I think that certainly is a time that is measured, that can be measured, obviously.
But the standard only applies if there's nothing beyond the traffic stop that would provide the officer suspicion or probable cause to believe that there's something else going on.
Right, yeah. So the traffic stop can be extended for a drug dog sniff if there is reasonable suspicion of a crime going on. And
the officer testified that he believed, based on all of this erratic behavior, that this was consistent with someone who was had been using narcotics.
Right, and
of
so,
course he just observed her operating a vehicle.
Sure, but I mean there was no
and driving 65 in a 40-mile-per-hour zone.
Right, yeah. So
and pointing a blowtorch at an officer at a stoplight.
Yeah, I mean I think
these facts are rough.
Right, yeah. I think these facts show a woman who is, probably not in a very good emotional place. She seems to have problems with police. She talked a lot about the issues that she had with police and, her daughter being taken and maybe the police not doing things about it and, talked about previous contact with law enforcement. So I think it's pretty clear that she doesn't like police, and she was expressing that in her behavior pretty clearly. And I think that's sort of what was going on with the littering and
Well, the littering, that's centered on the insurance papers, right?
right.
And she took them out of the envelope and then threw them on the ground and he said, pick them up and.
Yeah, so
And,
I think what happened there was that so he handed sort of maybe an envelope with insurance paperwork toward him and he said, "Can you get it out for me?" And I think she misheard him as "Can you get out?" And so she starts to get out of the car again. And he says, "No, no, no, you stay in the car, get the paperwork out." And I think at that point, sort of in her frustration, just her bad time that she was having, she gets frustrated and she throws them on the ground. She says, "You pick those up."
I like the term that you used in the brief, rude compliance.
Yeah.
So that was rude compliance and satisfied the officer's request.
Right,
Not
yeah.
littering, right?
Not littering. I mean, albeit in a rude way, she was doing what the officer told her to do, which was to get the insurance paperwork out of the car. And so I don't think it was littering such that he could have arrested her and then the car is just sitting in the parking lot available to be sniffed by the drug dog. And so, yeah, so to the extension of the stop, I think it's clear that, once she's arrested, if that arrest had not occurred and the traffic stop had been ongoing, there would have been an extension of that stop because Officer Janes, when she's arrested, backup arrives. He gets in the car, he starts writing up a traffic ticket, which is in the traffic mission that the cases talk about that officers are allowed to do throughout the pendency of the stop. And so then at some point, he decides to stop writing the ticket in the middle of doing so, gets out of the car with his drug dog, and then runs the sniffer around the car. And then ultimately, the ticket is never finished because drugs are discovered and, we go from there. But so I think it's pretty clear from the facts that that was sort of an extension of the stop by doing an activity that wasn't part of the traffic mission because he interrupted the writing of the ticket to then run the drug dog around the car.
I see that according to the timeline that I've read, the stop occurred at 1:54 a.m. She was placed into handcuffs at 1:57 a.m. and then the canine reacted as canines react at 2:02. So 8 minutes
Right. And then, there's
before the discovery of the drugs.
right. Yeah. And so I think, but ultimately, I don't think it's the amount of time that the extension was for that is relevant. It's the fact that it was a measurable extension. And that's the standard that the cases talk about. And so here we have a measurable amount of time that the stop was extended for.
Can we talk about the littering just a little bit? And that is so definition of littering is recklessly depositing or causing to be deposited any object onto public or private property. Why wasn't tossing the insurance card onto the ground something that met that definition?
I think that the depositing here is sort of the issue as I see it, that sort of is it's there to be left on the ground, right? And so in this case, you don't have it being deposited on the ground. You have it being given.
There's
in
a permanence requirement that is
I don't think
inherent
it's
in depositing.
Yeah, I think it's, sort of where it's going here, and which is on the ground. And so here in this case, it wasn't really being deposited onto the ground as such, more that it was being given to the officer, again, in that rude compliance way. And so I think that wouldn't be a depositing of the insurance paperwork onto the ground. So like if the officer had caught the paperwork, it wouldn't be a littering in this case because it was being given
those
to him.
weren't the facts here.
Sure. Yeah, but I think regardless of that, I mean, I think it's just, it was her complying with his orders and not depositing it onto the ground, but giving it to him. And so I think that's the difference between.
She was not charged with littering, though, was she? And
No, she was
not, certainly not convicted of it.
Correct. No, not charged nor convicted. So I see I'm getting close to the end of my time, and so I would just end with saying that the police extended Ms. Kuiper's stop in this case, and that the district court erred when it denied her motion to suppress, and the evidence should have been suppressed. And if there are no further questions, I would waive my time.
Other questions from the panel? All right, thank you.
Good morning again. May it please the court. The state appears by Deputy District Attorney Jody Litvin. And unsurprisingly, our position here is that the district court correctly denied the motion to suppress and that Officer Janes was correct in his analysis that she committed criminal littering in his presence. And alternatively, if this court does have a problem with the criminal littering charge, that there was reasonable suspicion to measurably
Why
extend.
should we be concerned about that at all? She wasn't charged, wasn't convicted. Can we even review that charge?
I think you can review.
If there was a claim, if it was a pretextual stop, he didn't stop her because of littering. He arrested her for littering.
Yes.
But how can we even review this? Because it was all, he arrested her for that. And then things from there, and then the charges flew. So I don't understand why we should be worried at all about littering.
Well, I suppose my response to their challenge was without the arrest and then subsequently without reasonable suspicion, we don't get to the drug stop or the drug dog running
Well,
around the
there's
car.
plenty of evidence for that. Holding a blowtorch outside, do you know, was it lit?
I believe in my facts that the officer testified that he did not believe the blowtorch was lit. I think I don't know that you can see this from the axon, the prior waving it outside of the window. So I think his testimony was that it was not lit. I know she picks it up again at some point during the stop and is kind of waving around a yellow blowtorch, but no, I don't believe it was lit. But his testimony, I think, was throughout the hearing was this was an abnormal stop from the start. And I agree. I think there is plenty of evidence for reasonable suspicion to extend the stop, even if we didn't have the littering. I think the way that she pulled over, well, first of all, no one contests that the initial stop was for speeding, 65 and a 40. The way that she pulled over was interesting to him. Again, abnormal, not just pulling over to the side of the road, speeding up, accelerating, then pulling into a parking lot, kind of abruptly stopping in the middle of this parking lot, and then getting out of the car. So immediately we have things that are not normal for a typical in his training and experience car stop. So, and then from there we have her just kind of erratic behavior. And this did all happen within a very short period of time. Her kind of saying things contextually that don't make sense, talking about her daughter being stolen or taken or somewhere in Lawrence, talking about she has an ankle monitor and can do whatever she wants. I mean, there's a lot of very rapid talking, mumbling, erratic behavior. Something seems off from the get-go.
Did the officer ever administer any sobriety tests, anything like that?
Not to my knowledge, Your Honor, no.
All right.
And it wasn't, and I don't think he ever testified that this was under the influence of alcohol. I think he specifically said this seems like someone who is under the influence of narcotics.
There's a doctrine in the State versus Wilson, where the Supreme Court's held that you can use a drug dog on a parked car, and doesn't involve a lot of these tests in a public place. Does that apply here? Or is that your argument?
I cited to it in my brief, Your Honor. Based on what the district court held here, I think both parties below in their motion to suppress said the officer didn't have reasonable suspicion. The state said they did have reasonable suspicion. The court didn't go with that. It went with, we have an arrest for someone, a legitimate arrest for someone who committed the crime of criminal littering. And that car was not parked in the street illegally. So the car was parked kind of in a public parking spot legally. And the court held, although Wilson wasn't out, I don't believe at that time, he had a couple of 10th Circuit cases, I think, or federal case law that said, if there's a car that's publicly parked and she was not going to be able to, she was being arrested, not being able to get back into it, you can run the drug dog around this legally parked car. So
It seems to me, though, that she parked the car there because the officer was pulling her over.
she was being stopped. That's true. Although she didn't pull over. It would be different if she pulled over to the side of the road. I will admit that if those were the facts and something had to be done with that car and it wasn't legally parked, I don't know that this would apply. But the facts are what they are, and she did pull into that Crunch Fitness parking lot, so it was legally parked. So I do think Wilson helps us in this case.
Does that turn, does the application of Wilson turn on whether that arrest is valid?
I'm trying to remember the facts in Wilson. I mean, in Wilson, I think the defendant had a suspended license, so was not going to be able to drive the car. So
There has to be a reason why the person is not going to be able to drive the car and the car remains.
correct.
And is the only reason here that the district court found the arrest?
I believe so. I could look back at his reasoning, but I believe he said there was an arrest here. And like I said, neither of the parties, well, I think it was sort of challenged, but in the motion to suppress, but the court basically said there was a legitimate arrest. And I think under Wilson, there was some language that said like, usually when the person is detained, the car is detained. But there was kind of this break where if this person wasn't going to be able to drive the car, then the car is not going to move and it's going to be there anyway. So yes, I think the reason here that she's not able to get back into the car is because he was arresting her for the criminal littering. Because the search happened after that and he wasn't in the process of writing his ticket. You know, we don't have like a multitasking situation here where someone's writing the ticket and then another person is doing the dog, so it's not measurably extending the stop. He was one and the same. He starts to write the ticket and then goes and stops and does the drug dog. So
What if we disagreed that the arrest was valid? Let's just say we agree with your opposing counsel with regard to the definition of deposit or something along those lines, and we don't think that arrest was valid. Could we reach the reasonable suspicion question in the absence of findings by the district court?
I think this court can, because I think it's a de novo review on whether reasonable suspicion exists. So I think this court can look at the facts that were established at the motion hearing and apply that. And with
Were those facts in any way contested? And I ask because we have some case law that says if a district court didn't make any findings, then we're not in a position to make those findings ourselves.
I'm blanking on whether the facts were contested. I don't think I can, I mean, the initial stop wasn't contested. I don't think I think the axon is what it is, so to the extent that disagreed with anything that the officer had said at the motion hearing, the court can watch the axon and watch what happened. So I think that those facts are for the court to look at. Maybe you don't have deference from factual findings from the district court, but I think whether reasonable suspicion exists is a matter of law that this court can get to.
Thank you.
And I really didn't have much further presentation, just to say that we would ask this court to first find that this was a legitimate arrest for criminal littering. Alternatively, if not, there was a reasonable suspicion, articulable, particularized facts here from Officer Janes to measurably extend or to allow for the extension of the traffic stop to run the drug dog and affirm the convictions and the motion to suppress, the denial of the motion to suppress here.
Before you take off, I was wondering if you could address the depositing, the depositing question about what that means.
Sure. I don't think I think I just cited to the statute and said the facts here are that she threw it on the ground, it's depositing, and that's what we have to go with. I think I tried to research some. I've never dealt with this crime before to know if there was any other case law.
It's not a crime that comes up on appeal very often.
Correct. Yes. I think this is the first time that I've actually dealt with it. But the state's position would be that depositing it was her action of just simply throwing it on the ground. It doesn't have to be a permanent deposit. I mean, she tossed the thing out. She wasn't going to hand it to him after misunderstanding to get out of the car when really he said, get the papers out. Our position would be her. And she throws them and says, you can get that. You can pick that up. So I guess our position would be that under the plain language of the statute, she recklessly deposited it when she threw it outside of the car. But I don't really have more than that, Your Honor, to go off of.
Any other questions from the panel? All right, thank you.
Thank you.
Counsel, you have 3 minutes for rebuttal.
Grace Tran of the Appellate Defender Office. So first, you talked a little bit with opposing counsel about Wilson, and so I wanted to address that. And I think, Your Honor, the application of Wilson does turn on whether there was the arrest in this case, because in Wilson, The court said that the issue was that she couldn't legally drive the car away from the scene. And that's why the sort of Fourth Amendment nexus between her and her car was severed. The drug dog could be run around the car. And the court specifically even says, the issue isn't whether or not she was arrested. It was whether or not she could legally drive the car away from the scene. And so in this case, if Ms. Kuipers was not arrested, her license wasn't suspended. There wasn't an indication that she couldn't drive the car away from the scene. And so I think, unless the arrest was valid, Wilson doesn't help the state here. And then second, I wanted to talk about reasonable suspicion. And I do think that this court can't get to reasonable suspicion at this point on appeal. So the state, I believe that the state didn't argue reasonable suspicion below in their motion. They just argued that it was, there was the arrest and then the drug dog could sniff the car because it was in a public place, and that gave, the ability to search the car. And then the district court didn't ever make factual findings on reasonable suspicion. And so I think, given that it was the state's burden below on a motion to suppress, and then the district court never made any findings, there would have needed to been an objection by the state or something to get the district court to make those findings so that they can now be reviewable on appeal. So I don't think that at this point we can get to whether or not reasonable suspicion existed. So with that, I would just ask this court to reverse the district court's decision on the motion to suppress. Thank you.
Thank you. Other questions from the panel? All right, thank you very much. Thank you to both counsel for your arguments today. We'll take the matter under advisement and issue an opinion on the case just as soon as we're able. At this point, we'll take just a second and let the council readjust, and we'll call the second case on this morning's docket. That's case number 128358 out of Riley County, State of Kansas, Appalachia versus Lawrence Joseph Ekdahl, appellant. Would the parties please state their appearances?
May it please the court, Sean Randall of the Appellate Defender's Office on behalf of Mr. Ekdahl, present, ready for argument. Your Honors, I would request 3 minutes for rebuttal.
3 minutes are granted.
Thank you.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas, present and ready for argument.
Thank you. Welcome, counsel. And Mr. Randall, you may proceed.
Good morning, Your Honors. As I said, Sean Randall of the Appellate Defender's Office on behalf of Mr. Ekdahl. At the risk of oversimplifying this case, what this court has to do today is determine whether the district court came to the correct legal conclusion that the emergency aid exception relieved the government from breaking into Mr. Ekdahl's house in the middle of the night when he wasn't there without a warrant to address a smoke detector that had been going off but had stopped sounding before they even entered the premises. And under the totality of the circumstances in this case and the evidence presented in this case, this court cannot judicially sanction such conduct and should reverse the decision of the district court.
Counsel, I'd like for some clarification on your position on this, because I don't think there's any dispute. This is a duplex. The neighbor is saying that alarm keeps going off. It's 1:30 in the morning and they said it had been going on for some time, correct?
That's all correct, Your Honor, yes.
And the fire department comes, they don't go in
Correct.
at that time. They stay, then the police come. The police open up a window, unlocked, I think.
You're right. Well, yeah, they removed the screen and then, yes, opened up the window and climbed inside.
One of them climbed in, opened the door, firemen go in. Is there any way that we could tell, is your position that this was all improper because this would go on and off, right? The alarm?
Well, I think it's very important that we.
What was unreasonable? I
I'm
want to
sorry?
know what was unreasonable in your view.
What was unreasonable was entering the home without at least attempting to get a warrant. I mean, just end all be all. That's the ultimate.
And what warrant would they get?
Well, and
from what court?
I don't know if we can be sure. But I would suspect that if a law enforcement officer went before a magistrate and said, this alarm is going off, it's been going off for some time, it's loud enough that I can hear it from the outside and that the neighbor can hear it. We have contacted the landlord, we have contacted the tenant, we've been unable to do so. Can I get a limited warrant for the limited purpose of going in and abating this noise complaint, nuisance, whatever it happened to be? I think it's possible. But we don't know in this case, and we don't need to answer that question in this case because the ultimate fact was it stopped. It had ceased sounding by the time they entered that house.
Wasn't the fear that it was carbon monoxide and it was carbon monoxide alarm that was going off that stopped? But there was a motorcycle there that belonged to whoever was renting it, and there was another vehicle there, wasn't a pickup truck parked there? in the
There were two vehicles that are parked outside, but I don't think that those vehicles parked outside, I don't think can be enough to indicate that it would be objectively reasonable to believe that someone is inside that house. There's all sorts of reasons why your vehicle might be parked in your driveway and you're not at the residence.
Was it one of the firemen that saw, you could carbon monoxide, you'd be asleep and then die from carbon monoxide and not hear the alarm?
Well, right. If you stay inside after the alarm, but I think that's the point, is that the alarm had been going off for 3.5 hours. I mean, what does an alarm do? It wakes you up from your sleep, or you get up and you figure out why it's sounding.
Not
or
if you're dying.
Right, but I can't imagine.
You see their concern? Isn't that a legitimate concern?
I don't believe so, Your Honor, and I don't believe that that reasonable concern was shared by the officers, or more importantly and specifically the fire captain who arrived on the scene at this case. I mean, he testified specifically, if it was an emergency situation, if you thought that there was someone that needed help, you would have made entry already without waiting for the police to arrive, correct? And he responded, if I saw that there was for sure a problem that I needed to act on, yes, I would have gone in. And he also testified.
That's for sure, right? If I thought for sure that there was a problem, we're left in that kind of question, this nuanced realm of reasonableness, right? It's not that there's smoke and flames coming out of the house. Instead, there's this ongoing alarm. There are cars that are parked out front. And is someone in danger in that home?
And I don't believe that they did believe that someone was in danger, again, because he said he would have gone in. But more importantly, he was also, you didn't actually have any evidence of a fire or carbon monoxide at that time. Is that correct? He responded, correct.
Counsel, you keep emphasizing that the alarm went off, but it did resume right after the officers got back in there, correct?
No, that's incorrect. I believe the state does indicate in their brief that the alarm sounded a moment later. If you go back to the record site stated in the state's brief, that's not what the court said, and that's not what the testimony was. It said that it sounded at a later moment, not a moment later, but at a later moment.
But it started sounding again.
At some point, yes, but I don't believe that the court really needs to address that, because we need to look at what did the officers know when they entered. Whether the alarm did or did not sound at a later point, I believe, is beyond really the relevant inquiry in this case. And more importantly, if you look, I think the body cam of the officers when they entered into the residence is part of the record in this case. It's about 6 minutes long. The entire time when they first enter the house, unlock the door, walk around, do all of those things, the alarm's not going off at that time. It's not sounding when they enter. It's not sounding when they're inside the house. Nothing's going on. They're not finding anybody until they go upstairs and they discover the marijuana plants. But when the alarm did sound is not really addressed as to how much longer they had been outside and what they had to do and all of those kind of
And
things.
they went back and got a search warrant, or the police got a search warrant, correct?
Yes,
And then the plants were seized
correct.
by using that search warrant,
Yes, correct.
not initially.
Right, correct. I mean, there were three ways that you can go inside someone's home. I mean, consent, warrant, ongoing emergency. We don't have consent. We don't have a warrant, And I would argue that we don't have an ongoing emergency. And I think, I mean,
What is the, if, you know, you have a fire department and then the police officers who are called to address this issue, there's an alarm that's been going off for a period of time, like a long period of time. This is not a standalone building. It's one that's attached to a neighboring property. There are cars that are parked in the driveway, or there's a vehicle that's parked in the driveway and the motorcycle that's also there. Is it reasonable for the authorities to just leave then?
no, I think it would be reasonable to go get a warrant.
Well,
I
for
thi-
what? I mean, the
I-
emergency aid exception is an exception to the warrant requirement that allows the law enforcement to address an issue that is exigent, to address an issue where you don't have time to go get a warrant. And so if you're wondering, is there a person inside who is dying of carbon monoxide poisoning? Is it reasonable to expect an officer to leave the scene and go and get a warrant and come back?
If those were the only facts that were available or were developed in this case, but we're looking at the totality of the circumstances, not just the cars parked outside and the alarm going off. I mean, the officers arrive, the fire department. I mean, the people we want who are tasked with going to and discovering and investigating these types of smoke detectors, alarms, whatever we want to call them, going off. They go out there. They don't enter. In fact, I think the fact that the reason why they called Mr. Ekdahl and why they tried to call his landlord was probably because they thought that they needed consent to go on inside. They obviously didn't make contact with him, but they walked around his house for 20 to 30 minutes. They knock on all the doors. They knock on all the windows. They touch the knob. They don't realize that there's any heat. They don't hear anything. They walk around the perimeter of the house with the thermal imaging camera trying to get any kind of heat signatures. They don't get anything. There just wasn't any reasonable, it wasn't objectively reasonable to think that someone was inside. There has to be more than just, well, there could be a person inside and they could be having a problem if this happens to be a carbon monoxide detection. And of course, it didn't turn out to be a carbon monoxide. It turned out to be a smoke alarm that didn't have its batteries, correct. It was malfunctioning for whatever reason. They go in there. You can see in the body cam footage of the fire department standing there, and they've got their little meter and they're walking around. They said this thing, tells 5 different things that could be we're not getting any readings of anything. And again, I understand what we're talking about.
But you don't know that until you're inside.
Of course. And that, but what I think what I'm trying to emphasize is that it's not just there's cars outside, this alarm has been going off. There's other circumstances and other things that were aware and known by the fire department before they called law enforcement. If there was an emergency, that's what they need. If there's an emergency, you're right, they don't need to go in. We would all hope that if there's an emergency, they go inside. But they didn't have any evidence. Again, question, you didn't have any evidence.
Help me understand the record. That delay was about an hour before the police came?
No, I think fire department showed up and was on scene for about 20 to 25 minutes. They call law enforcement. Law enforcement shows up about 10 minutes later, and they're there for a very short time because I think before law enforcement showed up, they had already identified the window that I think they said, this one's unlocked, you can, go in through there. So I would say it's.
But at least, it was at least 30, 40, 45 minutes?
Yes.
So there's no emergency after that. Is that your argument? They've been around, so there's no fire, there's no, of course, they don't know if there's anybody dead inside, but.
I would say that certainly the fact that the alarm stopped sounding before they entered the residence terminated any belief that an emergency is taking place. But again, if carbon monoxide was a real concern, if it was objectively reasonable to worry that there was carbon monoxide inside the house, the fire department testified, we've got carbon monoxide machines on our truck. And anybody asked, did you use them? No. Well, why not? Because we didn't have any evidence that there was carbon monoxide inside. If you look at the probable cause affidavit, submitted in this case, carbon monoxide isn't mentioned once. And I mean, whether it's an after the fact justification, neither here nor there, I suppose. But there was no objectively reasonable belief that there was a person inside or an objectively reasonable belief that there was that person needed the emergency assistance of personnel. I see I'm out of time. I'll be happy to answer any other questions or reserve any future questions for rebuttal.
Are there any other questions from the panel?
Okay, thank you, Your Honor.
Thank you very much, counsel.
Good morning. Again. This court should find that the district court did not abuse its discretion in dismissing or denying the motion to suppress because there is substantial competent evidence to support the district court's ruling, and the law also supports the court's ruling. What counsel or appellant is attempting to do today is asking you to reweigh the evidence, which this court may not do under the substantial competent evidence standard. There is clearly enough evidence there to support what the judge indicated, and Judge Hill, you were pointing out a lot of the facts that had gone into the court's decision-making process.
But isn't it our role to look at the totality of the circumstances to determine whether it was reasonable to enter the home at that time? I mean, we're not reweighing the evidence. We're looking at the evidence that's in front of us and determining whether it met the legal standard that was necessary.
Your decision-making is limited to the substantial competent evidence that supports the court's ruling. This court may not look at the totality of the circumstances of all the evidence, reweigh the evidence. That court may not do that. Now, granted, under the rule of the exceptional aid, emergency aid exception, this court would have to look at those facts that would support the court's ruling. Does that answer your question?
Sort of.
Okay. Counsel's trying to get you to reweigh and look at all these other factors. The court, I set these out in my brief. There are specific findings of fact made by the district court judge, and there is evidence to support that. The question for this court is, given those facts and the court's findings, does that support its ruling that the emergency aid exception applied in this case? And the state believes that quite clearly it does. Under the Neighbors and Fisher decisions, and granted, you don't have to follow Fisher, it's a Court of Appeals case, but the logic is there and it's consistent with federal law as well, where that indicates that emergency personnel need not be 100% certain that there is no emergency in existence. The law clearly indicates that emergency personnel are people of action, and they look at the facts in front of them and the evidence in front of them, and they make decisions. They don't need to be
Counsel,
100% certain.
What are we to do with the facts that it appears that there was some kind of a maybe inherent disagreement between the fire department and law enforcement as to whether there was an emergency that required entrance? Because the fire department was there for almost a half an hour.
Correct.
Before they called law enforcement. So it's if the fire department had thought that there was an emergency that required entrance, they certainly would have entered.
That was not the testimony. The testimony was they did not enter because the possibility of somebody being in there, and they were concerned about making an entry into that home. And if that person had a gun or whatnot that was in there, they were concerned about that. That's why they called the police in, because the police had the guns.
But
that was the explanation.
If we're talking about an emergency aid exception, not anything else. So if the fire department had thought that there was an emergency where someone's health or life was at risk, they would have entered. That's what the fire department does. So here we're left with, they get there and they kind of look around and they wander around and they eye things for about 25 minutes before calling the police. Is that really an emergency?
Well, the problem with your take on that right there is that's not what the evidence showed, and that's not what the district court found. The district court found that it was
answer my question
objectively reasonable.
Answer my question, if you would.
What is your question again?
Is that an emergency?
The fire department certainly believed it was,
Well, then why didn't they enter the home?
because they didn't want to get possibly shot. They called the police department to do that. and the district court
So,
accepted that.
so is it every time the fire department enters a house, they have to call the police department just in case someone's armed before they can offer aid?
I don't know that.
I
That
don't
was not
either.
the testimony in the case. Again, my point is, there was a suppression hearing, there was evidence put on, and the court's ruling was made based upon the evidence that was presented. It's not based on some hypothetical situation that did not come up in court. So the court made a decision that said, these are the objective facts. It was not objectively unreasonable for the fire department to act in the manner that they did.
Well, the fire department didn't enter until after the officer
That's correct.
went in,
Correct.
probably with body armor
I'm
and
not sure.
obviously with a camera.
I'm not sure. Yes. Right.
And went in and opened the door.
Correct.
Yeah.
And they cleared the house to make sure that it was safe for them to enter, then they entered. If that's the police department's procedure, that's not on trial here today. That's what the fire department said. There was no other motivation to do it. And to say that their procedures are somehow questionable because somehow after the fact, I mean,
It's not about, counsel, it's not about whether procedures are questionable. It's about whether under the facts of this case, there was an emergency that required entrance of the home without a warrant in violation of the Fourth Amendment.
okay. So you're saying, are you saying that it would have been okay for them to go in 10 minutes earlier on their own? I mean, if you're questioning the timing, why didn't you just go in? Why
The
did you wait
question
10
is,
minutes?
Given the facts of this case,
Correct.
were the actions reasonable?
Absolutely. Absolutely. If they could have gone in 10 minutes earlier, or 10 minutes later, I don't know what difference that makes. I mean, the subjective belief of the law enforcement officers is not important, or is it to be considered? However, in this case, I believe it can become part of the objective facts in the case. There was no intent or desire to enter that home, but to seek and make sure that there was no medical emergency or other emergency in that home. That was the only reason it went in. This isn't a situation where the police just went in on their own. They went in at the request of the fire department. So with that, I don't believe this court has any basis whatsoever to reverse the district court in this case. There's substantial competent
So
evidence to support.
you're framing the question subtly differently. Was the fire department's request for the policeman to go into the duplex reasonable?
Well, I mean, that's part and parcel, and I'm guessing that's part of Judge Warner. You're talking about the totality of the circumstances. I think that's part and parcel, but I don't think you can separate the fact that the only reason the police department went in was at the request of the fire department to make sure that they were safe and they could make safe entry. That was the only reason. That was consistent. So I guess I'm failing to understand how this court isn't bound by the court's findings, factual findings that are supported by substantial competent evidence. And the sole question is, under the law, do those facts as found by the district court, do they support its legal finding? That is the standard of review. Going beyond that in any shape or form is not permitted. And I believe, and I haven't seen anything in counsel's brief that indicates that somehow the emergency aid exception requires 100% certainty of an emergency. The underlying testimony was from the police department captain. We weren't leaving until we made sure there was not an emergency. And they did that. And to question how they did that, I think it goes beyond what the question is today. If there are no further questions,
I do have a question, just
Yep.
in light of what you just said. Is there a difference between saying we are here and taking action to address an emergency So to address an exigency versus we're not leaving until we make sure there's not an emergency.
I'm not sure I understand your question. They were there to address an emergency, and they said that they were not leaving until they made sure. I mean, it doesn't take a whole lot to imagine a situation where had they been there, they don't go in, and then, you know, the next day they start smelling rotting flesh, and somebody says, well, why didn't you go in there? You had the authority to go in there. I don't know what the second guessing is about in this case, quite frankly. They did everything in their power not to go in there. They called the numbers that they had. They knocked on the door. They did all that stuff. I mean, there wasn't an objectively unreasonable thing that they did that night. They didn't want to go in, but it was 1:30 in the morning. But had they walked away, I can only imagine the press. Oh my gosh, what were they doing? Why didn't they go in there? It would take them just a minute to go in there. But somehow, because we've involved the police, that this turns into this thing that's not an emergency aid exception. To me, the police are a tool of the fire department in this case. I mean, you know, when we deal with, let's say a fire, right, at a scene or something, the police are able to go in and they can help and assist the fire department in any manner at that point in time. Okay. They are basically a tool that the fire department is using. Now, whatever they find in that, they can use that evidence to go request a warrant or whatnot, but you know, whatever evidence they see. But once they leave that scene and they quit assisting the fire department, the police can't go back onto scene at a later time and just walk all over that scene. They've got to go get a warrant still. And so what we're dealing with here is, you know, they're a tool. They did exactly what they needed to do. They went in and cleared. They went and got a warrant. They came back, and that's what you have. I think it's notable that, you know, your comments regarding the search warrant. I mean, a search warrant for what? I mean, a search warrant for probable cause. You know, probable cause that a crime was committed, probable cause that this person committed it, or it occurred in this building. Nobody had crime on their bucket list that night. This was all about making sure a citizen of Manhattan, Kansas was safe with a baby. As it turned out, thankfully, it wasn't an issue. I think it's a red herring to talk about, oh, the alarm went off, so there's no emergency. Well, that's tone deaf. That doesn't even address what the issue was. The issue was it was going off for hours, 3 hours, I think, or so. And then when it went off, that didn't mean that there wasn't somebody still in there. Oh, the alarm went off. I mean,
Just for clarification, the alarm went off as the officer was going into the window, isn't that right?
it was something like that. I think he was,
Well, but my point
when he entered, he knew it had shut off for a minute.
my point is, if it was a carbon monoxide detector, opening the window could very well make it go off, right? That almost makes sense to me as to why the alarm would go off.
And certainly that could be true, but you know, that's a red herring to me. The testimony was the siren or the alarm was an indication that something could be wrong. And one of those things that could be wrong, for all the reason counsel stated, you know, oh, they said it's not a fire. They did the, you know, heat detection and all that. But the fact that the alarm went off, it really doesn't matter. It doesn't take away from the fact that there could be somebody in there either, you know, why did this person, if they were in there, what are the reasons? And we've seen the cases. Maybe they were passed out, incapacitated from alcohol or sleeping, a hard sleeper. I mean, I know people who sleep through things like that. Whatever it may be, the concern was about the person, not about the alarm at that point in time. So, any further questions?
Thank you, counsel.
The state requests that you affirm the district court in this decision. Thank you.
Counsel, you've reserved 3 minutes for rebuttal.
Thank you very much, Your Honor. Just to address a few things, Your Honor, I would clarify that the evidence is very clear that it was not, that the alarm did not go off upon opening the window. It shut off as they were removing the screen from the window before they then opened it. So it wasn't as
Like we're really splitting hairs here to me on that, but
well, I would honestly perhaps at least agree somewhat, that
Well,
whether.
help me understand, when you say the alarm went off, it quit sounding, is that what you
That's
mean?
correct. Yes, that's,
It could also mean it started again. So you're arguing that,
thank you for clarifying. Yes.
I like to be precise.
I appreciate it, Your Honor. Yes, no, it stopped sounding before they entered the residence. I think just to address a few of the concerns that were raised by my colleague, I don't believe that I'm asking the court to reweigh any evidence in this case. Again, it's the legal conclusion is that the emergency aid exception, obviates the warrant requirement. That's the legal conclusion that the court made, and you can look and should look, I think, at the totality of the circumstances to determine whether or not that legal conclusion was correct, and that's the de novo standard of review that this court employs. The state said that they didn't want to go in. Well, that's the point, because there was no emergency. They knew that it was not objectively reasonable to conclude that there was an emergency. The fire department testified, we had no evidence that there was a fire or carbon monoxide in the house before we entered. We had no evidence. There was no evidence. And this idea about this only matters because the police got involved. It has nothing to do about a difference between the police department or the fire department. The Fourth Amendment protects your home. And this is Mr. Ekdahl's home in the middle of the night when he's not there, and the police and fire are going in there without a warrant. And you only get to do that if you have an objectively reasonable belief that there's a person inside and that person is in need of emergency assistance. And I just don't believe that we have either of those things in this case. And that's why I don't believe that the emergency aid exception applies. And without a warrant, the entry into the house was unconstitutional and in violation of the Fourth Amendment. Any other questions?
Any further questions from the panel? All right, thank you very
Okay,
much.
Thank you, Your Honor.
Thank you to both counsel for your arguments and for your briefs. The court will take the matter under advisement and issue a written opinion just as soon as we're able. At this point, as I indicated, the court is going to take a brief, 5-ish minute recess, and then the court will come back and reconvene for the third argument. The court's now in recess.
All rise.
Please be seated. We'll continue the morning docket. In addition to myself and Judge Hill, we have a different third judge for this particular panel, Judge Catherine Gardner of our court. We will proceed with the third case on the docket. It is from Douglas County, number 127701, entitled The State of Kansas versus Darren L. Henry. Who do we have here for the appellant?
Dylan Pryor, Assistant Appellate Defender, appearing on behalf of Darren Henry.
And for the appellee?
May it please the court, the state appears by Senior Assistant District Attorney John Simpson.
All right. Mr. Pryor, you can begin, and do you wish to reserve any time for rebuttal?
Yes, Your Honor, if I could have 3 minutes for rebuttal.
That is granted.
Thank you.
Whenever you're ready.
May it please the court. The district court appointed Adam Hall to defend Darren Henry in the fall of 2020. Hall represented Mr. Henry for around a year and a half, with the district court granting substantial motions to suppress evidence during that time frame. Then, a jailhouse informant provided the state with a basis to seize and search every last piece of privileged material Mr. Henry possessed. Following that search, the state moved the district court to remove Hall as Mr. Henry's attorney, attaching nothing more than a privileged investigative report in support. Despite the district court finding that this report was work product, it nonetheless granted the state's motion, finding that Mr. Henry's interest and Hall's interest may at some point conflict.
Well, let me stop you there with the question. Hall was removed in the March of 2022, is that right?
That's correct.
And then about a year later, Mr. Henry has a motion to suppress, and Hall testified as a witness in that case. How would that have worked if he was still a counsel of record?
Well, so in that case, because that was a motion to dismiss the case based on the state's seizure and search of his materials, I think it would have been more than fine to just have Mr. Henry testify, like pursuant to Simmons, saying, yes, these are all because the issue there was, did these documents contain communications between Mr. Henry and Hall?
It was Mr. Henry's motion to suppress that evidence.
Well, there was a lot in that motion, but like it was primarily Mr. Henry moved to dismiss the case because the state's seizure and search of his materials had so prejudiced him that he didn't believe that.
Well, I guess my question is, if it was important enough for Mr. Henry to call Mr. Hall as a witness in this very important hearing, doesn't that kind of show that Hall couldn't have really possibly stayed on as counsel in this case?
No, Your Honor. At that point, I believe it's belt and suspenders because, I mean, at that point, Hall was already off, so he was available as a witness. I think Mr. Henry could have gotten just the same amount of evidence. It would have been the same if it was just him testifying that, yes, everything the state seized and it searched, that was all of the materials I possessed. It was all my work product. It had all my communications between me and Mr. Hall. So it wasn't cumulative, but it was corroborative. So he wasn't a necessary witness in that.
Well, the court also, if I understand correctly, removed the lead prosecutor in the case, correct?
That's correct.
So defense counsel's gone, lead prosecutor's gone. The court seemed to find the district attorney's procedures were lacking in several details. So what other remedy did the court have before it?
I believe the proper remedy was that it should have disqualified the Douglas County District Attorney's Office.
Now, why? Tell us why, because that's a big office, isn't it?
I don't know the exact number of attorneys there, but it's, I'd say standard size, probably a bigger county. But that would be consistent with how our Supreme Court has dealt with an adversary, like a party, like a member of a firm obtaining an adversary's confidential and material information, we have imputed disqualification.
The court went through a lot of this, and he said, recommended that they get the Attorney General's office to prosecute or get a special prosecutor, correct?
Yeah, and I believe, I can't remember the volume, but I know that Douglas County informed the district court that it had reached out to the attorney generals twice. They had said no in taking this prosecution. They reached out to Shawnee County, Johnson County, Wyandotte County. All of them had said, no, we're not taking this case. And so at that point, again, if they didn't want to, I mean, if the district court had disqualified Douglas County, then perhaps the attorney generals or another county would have been more likely to step in. But because Douglas County was going on, well, I don't know what they said, but there was no reason for another county to come in. But it would not have been too much to have another county come in. We have the attorney generals, we have the major crimes unit. They come in and handle cases for counties all the time. Here we see, I wasn't aware of this till this case, that counties will do reciprocal prosecutions. And so the idea that another county or the attorney general's office would step in to handle this prosecution isn't out of the ordinary.
This case, though, is out of the ordinary. Wouldn't you agree? I mean, we don't really have any precedent on imputed knowledge to attorneys that's directly applicable, because the cases you've cited are more when you have sequential representation, correct?
You're absolutely correct. And so I don't want to say I was flying blind, but that's why I believed it was a proper synthesis of everything following the adoption of Rule 1.10. Now I know we have Minnelli and I know we have comment 6 in 1.10. If this was, for example, like Dakota Loomis is now the district attorney there, comment 6 would say that, because he represented Mr. Henry in private practice, that imputed disqualification isn't there. We don't, and simply like a public defender that's, government going to government, that's not here either. And so that would be fine, but we don't have that here. What we have here, and this is my entire theory, is that when a member of a firm, and prosecutors' offices are firms, obtains confidential and material information of an adversary, then the proper remedy is to disqualify that firm.
What's your authority for branding the district attorney's office as a firm?
So the most recent is State versus Miller from our Supreme Court, where it reiterated what it already said, that under Rule 1.10, where we get imputed disqualification, a prosecutor's office is a firm. We also have the Wong case from 1989. We know that public defenders' offices are firms, and under Rule 1.10.
If my count is correct, there's 12 attorneys from the district attorney's office had access to this information.
The district court was ultimately not able to tell how many people had access or could access it or even had accessed it based on the evidence.
What procedures did the district attorney's office use to segregate this or protect this privileged material?
None.
Didn't they have a taint team or some way of sort of screening people out and not letting them have access to certain the documents that are at issue here?
They did, but again, we don't have these screening devices. The Kansas Rules of Professional Conduct, I guess good lesson for the 1Ls, is that we don't have screening devices in Kansas. In other states, we might be able to say, this prosecutor, you go and look through it and we'll just wall you off. We don't have that here in Kansas. Moreover, it wasn't proper for the state to be the one to search through it to find whether or not there were privileged materials. Our discovery statute specifically says it's the district court who determines whether something is privileged or not. And that was the purpose why Verona was there, because Rob, the police detective, or the police officer, and Nicholson, the detective, they wouldn't know what's privileged from what's not. So they used an ADA to be the one to make that determination. Statute doesn't contemplate that. Moreover, it's improper to have your adversary be the one to determine, whether something might be privileged or not. You don't want that bias. You want it to be before a district court who's neutral and detached. In some of these cases that I cited, although I didn't sign for these propositions, what happens in these cases is that the state will go and they will seize the materials, then they turn it over to the district court. And oftentimes the district court will then give it to a different district court judge, so the district court's not tainted by what it might see, and say, pluck out what's privileged, what's work product, what the state shouldn't have, and then give everything back then we can hand it over, because then we're not worried about any sort of discovery violations or the state not having something that it shouldn't, something that's protected by discovery. And then it can go through pursuant to search warrant to find anything that Mr. Henry shouldn't have had.
Let me ask you this. Did your client receive a fair trial?
I do not believe so. And I think that's what kind of goes more to my second issue, because what I think what we're dealing here, well, I guess they go to both issues, because we ultimately can't trust, I don't want to say I will say the legitimacy of it, because it's different from harmless error, where we can say, where there's the erroneous admission of evidence, and we can pluck that out and say, well, if that hadn't come in, everything else was fair. Here, after, with the imputed knowledge, once that information had gone into the Douglas County District Attorney's Office, we don't know how their prosecution was shaped by that. There's simply there's no way to know.
Or is it speculation to say it was shaped by it at all? What's the prejudice?
I think so, and that's what we see in a lot of cases. They say the defendant has to come forward and point and say, here's where here's what the state got that they.
Well, did they use this information to disqualify defense counsel?
They absolutely did. And I think that's correct, but I was also wondering about the trial. How can we know whether it's a fair trial? And there's just no way for Mr. Henry to know how that knowledge would have shaped the prosecution. Like, I think of an analogy, say 4 of us were playing cards all night, and Judge Gardner, you and I are across from each other, and I keep beating you. And once you're out of chips, you stand up, turn around, and you got to see there's a mirror behind you. And I was able to see every hand you had. And you say, you use that knowledge to beat me. And I tell you, show me how. Show me which hands I played that, were based on what I knew. You can't do that, because I kept my cards close to my vest. You never got to see, what I was playing with, what I had. And so it is, I think, an impossible standards for defendants to be able to point to a specific instance of, here's how this question was, affected by what the state learned. And that's the problem. I think it just goes throughout the entire prosecution. Once they see that confidential material, it's just impossible to know how it didn't affect the
I've got a
trial.
question about your second issue.
Sure, and I see we're getting under a minute.
Yeah, and that makes me crazy when it goes real fast like that. So I'm going to not try to look at it.
Okay.
What are we to do on that? I mean, that we're presented with a fait accompli. Do you want us to give you an advisory of opinion that we would not have dismissed defense counsel? Do we approve it? So what's the practical effect of that? Aren't you asking us for an advisory opinion?
No, absolutely not. What we'd say is that it was an erroneous decision to disqualify Hall. And when you disqualify counsel of one's choice, that is structural error. So the proper remedy would be reverse and remand. And I haven't talked to Mr. Hall, but it seems like it'd be proper to put him on, because that seems to be the whole issue here. We don't know how the rest of pretrial would have went. We don't know how the rest of trial would have went. I see I'm out of time. If I can.
Don't worry about that. You can still win this, though.
Oh,
Even if we find that it was okay to remove Mr. Hall.
mhm.
And your winning argument would be they should have disqualified the entire
Yeah,
county attorney's office.
that's correct. I have 2 ways to victory. Like, there were 2 errors of such magnitude that either one would require reversal. And so, yes, if you find for me on the first, I don't think you have to find for me on the second. You can avoid the, saying whether he had the right of continuing representation under the 6th Amendment. But
And you're not waiving your third argument?
no, absolutely. I'm sure this court is more than familiar and capable of handling whether an eyewitness identification should be suppressed. It's bailiwick, whereas these are more novel issues. So that's why I wanted to focus mainly on those. I am out of time. I want to respect the court's time unless it has any further questions.
I'm seeing that.
Oh, thank you very much.
May it please the court. As this court is aware, the parties have argued a number of things in their briefs, but
I've got a question for you, counsel.
Sure.
Were you did you participate in this trial? Were you one of the 12 or 13 of the DAs that saw this material?
So I'll answer your question, and then I have an additional something to add, I guess. I didn't hear about this case until I received the brief. Receiving the brief and looking through the record, I don't think it's fair to say that there was evidence of anything more than 5 people having had some exposure to the confidential information in this case.
As I understand it, the information was put into a computer and some sort of computer record.
So the Lawrence Police Department took 2 documents from the search, and it placed those documents into temporary evidence briefly, and then it placed them into its Spillman records management system. And there was some, I guess, unknown period, because we didn't have someone to testify about it, but there was some unknown period for not more than a day, but like where it was in that system, but the technicians for the Lawrence Police Department hadn't done what they needed to do to restrict access to only Agent Rob, who was the officer who was responsible for those.
Well, be that as it may, the Douglas County DA had a heck of a hard time finding anybody that could even take this case because they hadn't touched it before. Those are the facts, right?
Well, I don't know why we couldn't have another county assist us, or why they wouldn't agree to assist us. But I do know
if the court had ordered it, there wouldn't have been a choice.
Right. If the court had ordered it, I mean, yes, there would have been someone else.
But the court didn't order it, and I thought the record shows that your boss had a heck of a hard time finding anybody who could even do this case because they hadn't been involved in it.
Right. Sort of as an affirmative effort to try to take any precaution.
That's not a good sign, is it?
That no one else wanted to handle the
But
case?
practically no one in the office hadn't been involved in the case.
You're saying in an abundance of caution, people who had no knowledge of it chose not to have anything to do with it?
There was,
Or were there,
I'm
in fact, a lot of people had knowledge of it?
So the office didn't try to find someone else in its own, some attorney within its own office to handle the case. It was trying to find someone outside of its office as a precaution to avoid any issues. But once that it wasn't able to do that, there was no issue with finding an attorney who knew nothing about the case. And we know that the 2 attorneys who ultimately prosecuted the case knew nothing and weren't even around when these search events occurred.
Is the DA's office a law firm under
Yes.
our rules?
Yes, I believe so.
And those rules apply to the DA's office?
So the professional conduct rules apply to the DA's office. They say the DA's office should be treated as a firm, but they create special rules for government lawyers, like a DA's office. And those rules don't impute conflicts to the entire office. You know, they don't impute one lawyer's personal conflict to the entire office.
So there's a special rule under that if an attorney and you're the attorney next door, there's no imputation? What rule is that?
So comment 6 to rule 1.10 says that former client conflicts are not imputed to government lawyers associated with individually disqualified.
I'm talking about knowledge of information gained in the prosecution. Is that privileged?
Because we don't have a sequential representation. Former client doesn't squarely apply rules.
Right, and that's
1.10,
part of the
1.11.
arguments the government or the state has made, that those rules just simply aren't applicable here because that's not the proper framework for the remedy the district court had to, for the decision as far as what remedy the district court had to choose.
Well, if a public defender had obtained your confidential memo somehow in the case, would it be okay to just say, oh, we'll give this to another public defender in the office? Would that be a good enough remedy?
I mean, I believe that that's what the rules allow. Again, I think if in order for the state to have the entire public defender's office disqualified, it would have to prove that what the, what was required in this case, which is essentially that no prosecutor in that office could provide the state a fair trial. And that they were exposed, or there's some other circumstance that would preclude the court from finding there was going to be a possibility of a fair trial.
Your argument is that in 2007, the rules of professional conduct changed about imputed conduct to a government agency.
Yeah, if we're looking to the rules, I believe that the rules.
That's 20 years, right? 20 years ago?
Yes. But the reason I brought that up in the brief is because most of the cases, or all of the cases that Mr. Henry has cited, predate that rule change. So to the extent they are discussing any of the professional conduct rules, they're not discussing the rules that apply to this case.
I'm interested in that second issue that raised by Mr. Henry, and that's the disqualification of his defense counsel. Is he, what's your view on this? What can we do about that?
Well, I don't think this court needs to do anything. I mean, that's the state's position. I think that part of the reason for that is that Henry hasn't cleared an important threshold in this case, which that he hasn't shown he actually has a Sixth Amendment interest in the court having allowed him to keep Hall. And I think that's clear from the Supreme Court's case law, where it is said that the right to counsel of choice promises defendants nothing more than the fair opportunity to use their own means to obtain the counsel of their choosing.
The disqualification was based upon this belief that he could possibly become a witness because of this privileged material that the DA's office had access to, correct?
So
your office used it to disqualify your opposing counsel. That's kind of a clean sweep for you, isn't it?
So
you not only got privileged information, you used it to kick the attorney off.
So I believe I have 3 points to respond. First is that, again, in this context, the information we seized, well, the relevant issue was whether that information was protected by the attorney-client confidentiality privilege, not necessarily whether the evidentiary privilege for attorney-client correspondences or communications applied. But and I've already lost my train of thought, but I don't believe that there was
Well, let me ask you about the timing, which I think is relating to his question. At the point the state moved to disqualify Mr. Hall as Mr. Henry's attorney, had he already been named as a witness in a separate case filed against his client, Mr. Hall?
Yes, the state had filed the criminal solicitation charge against Henry in a new case, and its complaint named Hall as a witness. And I think I think it's important. So there was the potential that Hall was going to be a witness against Henry in the case. And there was also the potential that the state's, that the fact Henry had access, or the fact Hall provided Henry access to Abbott's personal information was something that he would need to defend himself for.
Two separate concerns.
Two separate concerns, yes. And I think the district court was justified in refusing to disregard those concerns and believing that the potential for those concerns was great enough. The potential for the unfairness to Henry and to all the parties in the cases was, and again, these are 4 cases the court had to consider, that all of that was too much to risk leaving Hall on as Mr. Henry's counsel.
Is there anything else the district court could have done besides disqualifying the whole Douglas County DA's office? I mean, it took off defense attorney. It took the prosecutor off the case. It suppressed the evidence that was the investigator's report, the attorney-client protected evidence. And it said this person, the investigator who'd been involved in looking at the documents and also in prosecuting this case we're here on now, would not testify. So did they tailor the remedy to the offense, or is there something more the district court could have done in between that and dismissing the whole county attorney office?
I don't believe there was anything more the court needed to do to satisfy the constitutional concerns here. Owing to
Did this man receive a fair trial?
the state's position is that he absolutely did receive a fair trial. And I think that's evident for a number of reasons. Mr. Henry has identified no instance where the record shows the state's prosecutors made unfair use of any confidential information. I know he's argued that there's a difficulty in proving that, but there are other reasons to believe it's not a problem in this case, because we know Nicholson didn't testify as the court ordered. All the evidence the state did use at that trial, or that another prosecutor could use at a retrial, pre-existed the state's intrusive conduct here. So it's not tainted by anything that happened. And that evidence incriminated Mr. Henry, to such a degree that, even had a different prosecutor presented it, beyond a reasonable doubt, the jury still would have convicted him.
Was the only reason the court didn't disqualify the DA's office is because you couldn't find anybody else to fill your shoes?
I can't speak to what was in the district court's mind.
Anything in the record that shows that?
I don't think there's any, it would be speculation to say that was what was in the district court's mind, because the record only shows that the state made an effort to try to find someone else. And
Did anybody ask the judge to recuse? Because by this time, the judge had access to all of this information, correct?
Correct. No, no one asked the judge to recuse.
Should we be concerned with that?
I don't believe so. I mean, I don't recall when Mr. Henry had new counsel and later filed a motion to dismiss the case. I don't recall exactly what materials the court may have reviewed in camera that might have exposed the court to confidential information. But we know that at least it saw the redacted Brunt report. And I don't believe there's any reason to suspect that the information that was in that unredacted information in that report.
Did the district attorney's office have an affirmative duty to protect this information, the confidentiality of this information?
I mean, the state had an affirmative obligation to respect the confidentiality.
And protect the information from dissemination?
Well, to protect the integrity of the case by not exposing the assigned prosecutors to the information, certainly. But it also had an interest in possessing the information because it was evidence of crime. And a crime that was very serious and almost jeopardy.
So that trumps the rules about confidentiality.
I think when a defendant uses information that might otherwise be confidential to commit a crime, the state has a right to gather that evidence to investigate and prosecute that crime.
Is that the attitude that was taken in the prosecution of this case?
Well, I mean, it was to the extent that the state filed charges and intended to introduce the evidence that Henry possessed of its personal information. But I don't know that it has anything to do with the state's attitude with respect to how it prosecuted this aggravated robbery case. And I see my time is dwindling, so unless the court has further questions, I just ask that this court affirm the district court's judgments and affirm Mr. Henry's conviction.
Apparently not. Thank you.
Thank you.
You still have 3 minutes.
Thank you. May it please the court, there were two issues I wanted to just address in my rebuttal. First, the state had brought up how looking at the rules of professional conduct is the improper framework that we should be looking purely at the Sixth Amendment. And I think, Judge Gardner, you kind of alluded to it. What U.S. versus Morrison says that after you found the violation of the attorney-client, basically the right to counsel, then it comes time to fashion the remedy. So ordinarily, we would just have the Sixth Amendment as our guide, but of course, we know that we can add to constitutional rights. And so once it came time to fashion the remedy, I think that's where Kansas law and around imputed disqualification comes in. It might not be part of the Sixth Amendment, but there's nothing that says when it comes time to fashion a remedy that you can only look to the Sixth Amendment.
So you're arguing a Sixth Amendment violation, but not the traditional Sixth Amendment remedy.
That's correct. And I don't believe that the state challenged the district court's framework for how it assesses whether there was a Sixth Amendment violation of the attorney-client relationship, kind of from like Weatherford versus Bursey and Morrison. So it's after what we're really discussing is whether the remedy that the district court fashioned was appropriate. And I'd say under Kansas law, it wasn't. Many other states and federal jurisdictions, we're only looking at Sixth Amendment cases, but here in Kansas, because we have the history of imputed disqualification, and even with that 2007 amendment, that still doesn't address the issue that we had here, because there is no ethical rule whatsoever. There isn't the sequential representation that Comment 6 would cover. What we're dealing with here is something entirely different from, a conflict to a previous client. We have an adversary obtaining confidential and material information, and there's nothing to suggest that that would have been affected by the change. And finally, just because the state brought it up, I would just ask it about the issue of whether Mr. Henry had a continuing right of representation by Mr. Hall. I'd say Wong is enough to say that we treat whether someone is appointed or retained. That's enough to do it. But if this court does have to wade into the question of whether a defendant who is appointed counsel has the same right of continuing representation by that counsel, I would ask this court to not take the state's path. I would ask it not to stratify the Sixth Amendment right to counsel based on whether a defendant is affluent and indigent. A defendant who is appointed counsel has the same right as one who retains counsel to have that attorney stay on unless the court has found a reason to disqualify that attorney. If there are no further questions, I'd simply ask this court to reverse. Thank you.
Thank you, counsel, very much, both of you, for your briefs and your arguments. We'll take the case under advisement and get a written decision out to you just as soon as we possibly can. And with that, this morning's hearings are adjourned.